Where are you taking me?
Jail. Go to jail for battery and trespassing.
Jail?
Yes, sir.
Against Miguel, and Nate grabbed him and pushed him out. Then that's when he started throwing beer on us.
That doesn't even make any sense. How can I throw beer on them after they grab him? Can you replay the camera for me?
When a man says he was trying to leave and security says he refused to go, whose account does the law require an officer to believe before making an arrest, and what does the Constitution actually demand before a warrantless arrest can proceed?
This is a lie. This is a lie, sir. Where are you taking me?
Jail. Go to jail for battery and trespassing.
Jail?
Yes, sir.
I asked to leave.
And you fucking threw the bottle on them.
No, I didn't.
I saw it. Stop. Buddy.
Sir, I asked to leave, buddy.
And then you throw what
Is
was
that
inside
easy?
the bottle on them. I
No,
saw
I
you in the
didn't.
meter.
I tried to put it
Are
down.
you fucking call me liar?
Exactly. I promise you, I'm not trying to leave.
Without.
That's my girlfriend right there. I tried to leave. She got pushed and I tried to leave. I'm promise you, I'm not trying to do that. I'm ready.
Do you have
to leave.
anything else on you?
No, sir.
That's good.
I promise you, I tried to
Sir,
leave.
don't make it worse for you.
I'm not trying to make it worse. I promise you, I tried to leave.
That's it.
I tried to
I
leave.
saw
He grabbed my
everything. Have a
girlfriend.
seat.
He grabbed my girlfriend. I tried to leave.
Can you put a seatbelt, please?
I tried to leave and he pushed my girlfriend. I tried to leave. That's all it was. That is my girlfriend right there. I tried to leave. What do you mean? Sir, I promise you I tried to leave.
I know, I hear you. Give us a second.
Sir, I saw he like splashed the beer. Did he hit you or somebody else?
No, he tried butting against us when we were trying to push him out the door.
Okay.
Trying to escort him to the door and everything, and
Okay.
he turned around and get your fucking hands off me like that, and bucked against Nate, and then or bucked against Miguel, and Nate grabbed him and pushed him out. Then that's when he started throwing beer on us.
So I'll take him for trespassing. If any of you want to press charge for battery? No? Okay, that's fine. Do you have like a camera there so I can see?
God.
Like inside, from inside.
Not sitting here at this corner, no. We're
Okay.
going to show this door, unfortunately.
Okay, no worries, we're good. All right, thanks, sir.
No, we were walking out. Like I
All right, ma'am.
Getting home.
Here's the thing.
Sorry, I'll just call the Uber.
Listen, they don't want to press charge for battery, which is
Okay.
good thing, but he'll still go to jail for trespassing and disorderly conduct a licensed establishment. You cannot spill a beer for anybody.
Okay.
I was there, I saw everything in my mirror. Alright? Thanks God he didn't throw that bottle on them. That's gonna be felony.
No,
Alright?
I swear, he didn't know there was a
He's
female
intoxicated. He like fucked up, alright?
bathroom. Okay.
He'll be released tomorrow, 9 a.m.
Do you know where I can pick him up? And when?
He'll be released tomorrow like 9 a.m. from
9 a.m.?
Monroe County Jail.
Monroe County.
It's like 2 miles from here.
Sir, please. Sir, all I was trying to do was go home with my girlfriend. He pushed my girlfriend. What's going on? I'm going to jail. Why? I'm in the Coast Guard. I'm just trying to go home, dude. What did I do? Sir, can you please tell me what I did? Sir, can you please tell me what I did? Trespassing, I tried to go home. He pushed my girlfriend and I asked him, what's wrong? Sir, can you tell me what did I trespass on? I can't hear you.
You were refusing to leave private property.
I tried to leave. I left with my girlfriend. He pushed my girlfriend. And I asked him what's wrong, and you guys put me in handcuffs. I promise you I'm not trying to do anything wrong. Sir, I promise you I'm not trying to do anything wrong. Do you have my wallet and my phone? Why did I get trespassed? I asked to... Dude, that's the worst part. I asked to leave. These handcuffs are really tight, man. What'd you say?
There are 5 minutes.
Dude, you put these on really tight, man. Who asked me to leave that I didn't leave? That's what I'm questioning. I asked to leave. The moment they questioned me, I asked to leave. I think you handcuffed me for no reason. Did you not see my military ID? What'd you say?
I don't care.
I'm confused what the issue is that I caused tonight.
Disorderly conduct of licensed establishment.
What'd you say?
Disorderly conduct.
Disorderly conduct for what?
For throwing beer on the security.
I didn't throw beer in the security. I asked to leave and they grabbed me. You're telling me after they grabbed me, I threw beer on them? That doesn't even make any sense. How can I throw beer on them after they grabbed me? Can you replay the camera for me? I don't even understand what I did. They grabbed my girlfriend and I said, please don't touch her, and then they got mad. I'm genuinely confused. Sir? Sir, may I ask where we going? To jail? What did I even do? What'd you say?
Trespassing.
On where?
Red order. Street block.
How did I trespass on Ron Gardner when I was asking him to escort me to the door?
And you're refusing to leave. You're trying to get inside.
I tried to leave, sir. How do you know?
Because I saw it in my mirror right here.
I tried to leave with you. Oh my goodness. All I was trying to do was take a pee. And I was trying to let my girlfriend pee and then some dude yelled at me. I promise you guys I meant no disrespect. I was trying to let my girlfriend leave. She was peeing and that's all it was. And some dude yelled at me for letting her pee. If you watch the body cams back, you'll see that. Am I wrong? Sir, I promise once you watch those cameras back, you're going to see I was trying to let my girlfriend leave. And that's all it was. What'd you say? I was trying to leave. I was trying to protect her. Would you not protect your woman? Would you protect your woman or no?
Alright, listen, sir. I understand you're in the military. Your charges is just a misdemeanor.
What is yours?
I said your charges is just a misdemeanors, right? They probably
You want me
will
to
be
step
dropped.
out?
Yes, step outside.
I promise you I'm not trying to charge you anything.
Okay, step outside. When you're gonna get there, they're gonna remove handcuffs.
Okay.
And you're able to make a phone call, okay?
Okay.
So you can call your girlfriend or wherever you need, or your command staff.
Well, I'm just confused. What did I don't even understand what I did wrong.
Okay, so they told you to leave.
Do you mean to press this button or you can?
No, I didn't. So listen. They
Well,
told
like,
you-
I'm confused. I tried to leave. Is that the issue? I
Then
promise you I'm
you-
not trying to do it.
When you try and fight with them, then you
didn't-
grab your
Have
beer
I tried to
bottle.
fight with you one time?
Not with me, with them.
But I promise you I didn't.
Okay, then you
What
have a
I
beer
like-
in your bottle, right?
No,
and you
no.
start doing like that.
My beer was empty. That's the issue.
I was there. I was
I know you were there. My
6
beer was
feet
empty.
from there.
I know.
Yeah, it's empty because you already spill on them everything.
I promise you I'm not trying to cause any issue.
Again, you will be released tomorrow morning. It's not a big deal. It's not a bad charges. It's not felony. They're gonna drop the charges.
I'm trying to go back to. I got a duty tomorrow. I'm not trying to cause any issues with you.
Okay, you'll be released tomorrow. There's a bench to the right.
Am I going straight?
Yeah, bench to the right. Just have a seat. Right there. Have a seat. They're gonna remove handcuffs.
These are really tight.
Is a rear-view mirror observation legally sufficient to establish probable cause? And when a handcuffed detainee complains of pain 3 separate times, does an officer's continued silence cross a constitutional line? These are not hypothetical questions. They are the specific legal issues at the center of this arrest. And the answers have consequences that extend far beyond one night in Monroe County. The Fourth Amendment prohibits unreasonable searches and seizures. A warrantless arrest is constitutionally valid only when supported by probable cause. Probable cause means a reasonable belief grounded in articulable facts that a specific crime was committed by the person being detained. In Graham v. Connor, 490 U.S. 386 decided in 989, the Supreme Court held that the reasonableness of any law enforcement action must be judged from the perspective of a reasonable officer at the scene, not with the clarity that comes only after the fact. Applied to this arrest, 3 sources support probable cause. The officer's own direct observation from his rear-view mirror, a first-hand account from bar security personnel, and the subject's own statements placing a beer bottle in his hand. Whether these 3 sources together meet the constitutional threshold is the core legal question. Criminal trespass in most jurisdictions requires 3 elements. The location must be private property. The person must receive clear notice to leave from an authorized party, and the person must refuse or fail to comply with that notice. The subject does not dispute the first 2 elements. His entire defense rests on the third. He claims he was already complying when security physically intervened. If a person is in the process of voluntary compliance when apprehended, the refusal element of criminal trespass may not be legally satisfied. Disorderly conduct requires both intent to cause public alarm or disturbance and an overt act constituting a breach of the peace. Intentionally throwing liquid on another person satisfies the overt act requirement in most jurisdictions, but intent is the dispositive variable. Without proof of intent, the charge does not survive legal scrutiny. The subject claims the bottle was already empty and that any liquid contact with security was unintentional. If accurate, the intent element is not established. This is a factual dispute that belongs to a court. It cannot be resolved at the point of arrest by the arresting officer alone. In City of Houston v. Hill 482 U.S. 451, decided in 987, the Supreme Court held that verbal challenges directed at law enforcement, including speech that is confrontational, emotional, or profane, are protected expression under the First Amendment. Verbal protest directed at an officer cannot independently constitute criminal conduct. In Miranda v. Arizona 384 U.S. 436, decided in 9966, the Supreme Court established that a person in custody must be advised of the right to remain silent and the right to counsel before any custodial interrogation begins. No Miranda advisement is documented on camera in this footage. Voluntary and spontaneous statements made without interrogation are generally admissible. However, the absence of a document advisement creates an evidentiary risk at trial. When statements made in custody become contested at a later stage, undocumented procedure consistently weakens the prosecution's position. In Kopek Tate 361 F.3d and 772, decided by the Third Circuit Court of Appeals in 2004, the court held that an officer who ignores a detainee's timely and specific complaint about handcuff tightness after the subject is secured and no longer poses a threat may be held liable for a Fourth Amendment violation. The subject in this footage complained of handcuff tightness on at least 3 separate occasions. The officer did not check or adjust the restraints at any point visible on camera under the standard established in Kopek v. Tate and adopted by multiple federal circuits. This represents an area of active civil liability exposure for the officer and the department. Active military service does not create immunity from state criminal law. However, a misdemeanor arrest may trigger adverse administrative consequences under military regulations, including security clearance review and adverse action in a service member's official record. Criminal proceedings and military administrative proceedings operate on separate tracks simultaneously. The first practical lesson from this incident applies to civilians. Physical compliance and silence are the most effective legal strategies available to a person being removed from a private establishment. Verbal protest, however justified, does not prevent an arrest. The appropriate forum for challenging an unlawful arrest is a courtroom, not a sidewalk. The second lesson applies to law enforcement. Officers have an affirmative obligation to check handcuff fit once a detainee is secured and expresses a specific complaint about pain. Failure to act on that complaint may independently constitute a constitutional violation, regardless of whether the underlying arrest was otherwise lawful. The third lesson concerns evidence preservation. When the only direct observation of a disputed act is captured in a rear-view mirror rather than a body-worn camera, the evidentiary foundation of the charge is inherently weaker. Interior surveillance footage from the bar is the dispositive evidence in this case. Its preservation should have been requested immediately at the scene. Several questions remain without answers. Did the bar's interior camera capture what the officer reported observing from his mirror was the liquid contact deliberate or the unintended consequence of a physical struggle? If the subject was already in the act of leaving, can criminal trespass be legally established? These are questions a prosecutor must answer before proceeding to trial. The officer stated on camera that the charges would likely be dropped. That statement is procedurally unusual. It is documented on recording. Does it reflect an honest assessment of a legally insufficient case? Or is it a de-escalation tactic with no bearing on what follows in court? The subject identified himself as an active member of the Coast Guard. Were there administrative consequences that followed this arrest, even if criminal charges were never prosecuted to conviction? A dismissed charge and an undamaged service record are not always the same outcome. This footage does not resolve the case it documents. It raises questions about probable cause, evidentiary standards, officer obligations after an arrest is made, and the limits of what a rear-view mirror can legally prove. What happened inside that bar may never be fully established. What happened outside is on camera, and that record raises more questions than it answers.